Welcome to CAM Radio, an ahead of the curve initiative by Cyril Amarchand Mangaldas, bringing you every Friday the latest in legal and policy. Stay tuned, enjoy listening.
We spent 3 years from December 1946 till November 26, 1949 framing our constitution. So it was a very well imagined constitution. We from subjects we became citizens. We have a very long constitution. So the framers gave us a civic culture. It is 395 articles. It's one of the longest constitutions to create a new grammar for the country.
The Solvency and Bankruptcy Code of 2016 is another transformative legislation which brought about a market for corporate control, as well as engendered accountability and good corporate governance. I think big tech in any event has such an outsized impact on each of our lives that I think there is a risk that they are arrogating to themselves certain powers of the state. So for instance, they run what used to previously be called the public square. So they are effectively in charge of adjudicating free speech, which is a function that the state has to carry out. AI embeds in itself certain flaws that humans already have. So as we're looking at AI to replace humans, there is the risk, of course, that human flaws such as bias and prejudice, whether it's racial or gender related or related to faiths, etc., can get not only embedded in AI but compounded and amplified by it. And that is something to be quite wary of.
The softer aspects, such as fundamental rights, such as the clarion call of the preamble, which speaks about fraternity and the dignity of the nation and each individual. I think those are far more important than all these technological developments. So as a citizen of the country and as a citizen of the world, I definitely feel that these founding tenets should guide us forward and will be the differentiating factor.
Welcome to a special edition of Cyril Amarchand Mangaldas CAM Radio, Clear Cut, Clarity with Class. This podcast minimizes the mayhem and crafts clarity with care and class, befitting the name Clear Cut, talking about the issues that matter and pertinent legal aspects of these issues. With CAM as a beacon, illuminating the intricate tapestry of India's legal landscape, today we are celebrating the 76th anniversary of Indian independence. Today, let's traverse the legal corridors that have shaped India's destiny, what is coming up, and what could mold the nation's future. In 1947, India had a new dawn, ushering in an era of sovereignty and self-governance. But that dawn did not just bring in political transformation, but the meticulous crafting of a constitution became the moral compass of our nation. But this podcast is not just a nostalgic glance back. No, it's a celebration of dynamism. It's a tribute to the transformative legislation that has empowered our nation in its evolution. And as we explore the terrain of Indian law's future, is it more rocky or will it get smoother with time? How do we strike the balance between innovation and tradition? Will technology be wielded as both the sword of justice and the shield of rights? Can the hollowed halls of our courts best serve the environment? How will India's past shape its future? Joining me today in this discussion are Richa Roy and Yash Johri from CAM. Richa, I would like to begin with you, and it's kind of an open-ended question. I think it's a very, very smart question to also begin the conversation with is, how has the unique blend of cultural heritage and legal innovation in the Indian Constitution shaped the legal identity of modern India?
Thanks so much, Richa, and that was a beautiful introduction to start with as well. You referred to a new dawn for India that emerged in 1947, and I think when most people think of that, they think of Prime Minister Nehru's Tryst with Destiny speech, where he said, history begins anew for us, which we will live and others will write about. And it's also important to remember that the Constituent Assembly was sort of in, debating and writing the Constitution at that stage. And he specifically said that freedom and power bring responsibility to the Constituent Assembly. And so the Constituent Assembly drafted a constitution that was indigenous. So it's really important to remember that this was not a gift of the West. This had some very specific provisions and rights that were granted to Indian citizens, and held the Indian state accountable, because it was a government that would be created of its people. We'd moved from being subjects to citizens. And the Constitution was not an elite project at all. And I think the work of scholars has also shown that in the early years of the Constitution, there were sort of several people that were traditionally considered subaltern that held the state accountable through things like writ litigation. It was also ingenious. It was rights-based. There was a doctrine of separation of powers, and it allowed for jurisprudence to be built, which allowed an expansion of these rights. So the right to life under Article 21 has been interpreted in very creative ways since then to continue to expand the rights that are available to Indian citizens. And also, the Constitution is a living document, and it evolves with the socio-economic needs of the country. And the recent most example of this is the Data Protection Act, which came into force just this week. And this emerged from a decision of the Supreme Court in Puttaswamy, the right to privacy judgment, which in turn derives from the provisions of the Constitution, Article 21, and the right to privacy being part of the right to life, as well as sort of reams of important jurisprudence that has emerged over the years and which has been cited around the world as well. So the Indian Supreme Court has been a leader in rights-based jurisprudence.
Thanks for that, Richa. You spoke about quite a few things. You called it ingenious. You called the fact that we sort of moved from being subject to citizens. But in totality, the Indian Constitution really has been called a living document. Do you really think that adaptability allowed it to address contemporary challenges while preserving its foundational principles?
Absolutely, Shrija. That's an extremely important point. And I think this is something that developed partly through jurisprudence and through various contestations that occurred regarding the Constitution in its early years. So the Constitution was amended several times, and that's something that reflects its adaptability. And it was also interpreted by the Supreme Court in multiple ways. And it was one of these interpretations by the Supreme Court that created the doctrine of basic structure, which said that while the Constitution can be amended by Parliament, there are certain principles which are considered sacrosanct and basic structure and cannot ever be amended. And this included things like federalism. This included things like the fundamental rights. This included the doctrine of separation of powers. And so this unique sort of creation of the ability to be malleable and be sort of a living document, but deeply rooted in its original principles, is something that's allowed the Indian Constitution and the legislation that emerged from it and executive action to respond to the dynamic needs of an emerging nation and economy.
Shrija, if I could supplement Richa on this point.
Sure.
So Richa spoke about, your question was pertaining to the adaptability of our constitution, while at the same time maintaining the essential foundation of the way the constitution was brought about. And I feel like that's been a trope across the development of our constitution. And I just want to point out two factors over here.
Sure.
Number one is that we have to understand that the average lifespan of written constitutions since 1789 is 17 years. Why has our constitution, we're already in its 77th year. So the very reason, there's two reasons I believe the two most important reasons are: number one is that we, as Madhav Khosla says, we have a truly imagined constitution. We spent 3 years from December 1946 till November 26, 1949, framing our constitution. So it was a very well imagined constitution. As Richa said at the start, we from subjects we became citizens. We have a very long constitution. So the framers gave us a civic culture. It is 395 articles. Is one of the longest constitutions to create a new grammar for the country. Second of all, they endowed the state, which is the Indian state, which we'll come to in time as to why it was such an overarching concept, is because the framers only thought that the Indian state can mediate the various diversities, religions, castes, etc. So that was the reasoning for that. And number three is that during that time when partition had just taken place, there was an impetus to divide people on the basis of their group identity. But at that particular point, when the burning embers of the partition were still there, our leaders, our framers, had the foresight to base identities on individual identities and let the politics of a future day formulate the identities as we're seeing playing out in today's day and time. And the second most important thing, to my mind, is what Richa stated, was the basic structure theory. And if you look around us in Nepal, there's been multiple constitutions. In Pakistan, there's been multiple constitutions. In Thailand, for example, in 1997, there was a very well imagined constitution, but the ruling generals came back 9 years later and scrapped it. In the same vein, in India as well, there were various attempts by the executive to totally reframe the constitution. And it was the judiciary in 1951, 1965, and 1973 in the famous Keshavanand Bharti case, which laid down the basic structure, and in turn put this basic structure theory also gave the court the power of judicial review. So if the parliament passes any bills that impinge upon the separation of powers or impinge upon federalism, we can still go to the Supreme Court and have it struck down. So the powers of judicial review was massively expanded, and it's only recently in England where we saw the controversy which happened with Boris Johnson on the proroguing of the Parliament, where there was such a big debate in England that the power about the powers of judicial review. But in India, we've had that in our very nascent stage of development. So I believe that these two points are very important to understand how we've managed to adapt. We've had more than 100 amendments to our constitution, but we've kept the basic spirit of our framers alive.
Thanks for that, Yash. We spent some time on the Constitution, understanding that how it has really been able to adapt itself, address contemporary challenges, but still preserve its foundational principles. Now it is time to take the conversation forward. Let's talk and spend a little bit of time about transformative legislation in India that has really reshaped this country's economic landscape. Could you perhaps paint a before and after picture? And how have these laws really turned the wheels of progress? What really are the key lessons we have learned from the implementation?
So, Shrija, in the early years of our life as a republic and an economy, we were a fairly poor nation, and we were suffering from sort of colonial excesses which had hollowed out our economy. And so we had an important task before us, which was to rebuild our economy. And at that stage, the best avenue to do this was actually through the state. And this was the prevailing economic consensus at the time as well, that the commanding economies of the state is what could recreate the economy. And so in that context, we had a range of legislation that gave the power to the state to build sort of important industries in terms of infrastructure, heavy industry, etc. It allowed us to build important economic institutions including sort of, regulators who checked economic excesses. And it also allowed us to build centers of excellence, the benefits of which we continue to reap today. These include, the institutions of learning, such as the IITs and, the institutes of design, etc. So that was sort of phase one. As we moved forward, there was also a need where there was private enterprise, and it was being carried out in a way that was exploitative, to perhaps nationalize them. And banks were nationalized, coal mines were nationalized, all through legislation. And while there has been sort of mixed reviews about the manner in which these important industries were nationalized, there is a lot of data, including by economists, that demonstrates that some of these things were required. And the nationalization of banks, which took place in the 70s and then was in fact upheld by courts as well, even though they had the power of judicial review, as we discussed, it has demonstrated that that led to a deepening of financial inclusion and allowed banks to penetrate through the hinterland of the country. So that was really phase two. And then we come to phase three in 1991, where there was a liberalization and where private enterprise was again welcomed. Foreign investment into private enterprise was welcomed. Now, again, there is a bit of a misconception around this as to whether this was something that was dictated by Bretton Woods institutions, by the World Bank and the IMF. And while it is true that there was a balance of payment crisis at the time, it was actually, something that the Indian government at the time chose to do by making amendments in a series of policies and a series of laws and regulations in order to welcome private enterprise and foreign investment. And since then, it has been a sort of a regular process of tinkering and incremental improvements to the laws and the regulations that govern our economic life. For instance, soon after liberalization, there was a issue with our securities markets, and then the Securities and Exchange Board of India was created through the Securities and Exchange Board of India Act. So there is a statutory framework through which the regulator operates, and its powers are checked. Similarly, with financial markets, the Reserve Bank of India was created way back in 1936, but has been, that constituent statute has continually been amended to give it new powers to deal with the changing financial landscape. And similarly with the Banking Regulation Act, which was in the year 49, but has sort of regularly been amended. And this continues until fairly recently, and we can discuss some of the more recent legislation that deal with the emerging trends of the economy. But the Insolvency and Bankruptcy Code of 2016 is another transformative legislation, which brought about a market for corporate control, as well as engendered accountability and good corporate governance.
Okay, thanks for that, Richa. I think you've spent some time discussing the past, essentially what really played a huge role in transformative legislation in India, reshaping its economic landscape. I want to spend some time on the present now before we take a peek into the future. Let's talk about something as transformative as the Insolvency and Bankruptcy Code, which literally revolutionized the way India handles distressed assets. It is transformative, extremely imaginative in scope, and actually brought change on the ground. I want to understand from both you and Yash that what has this legislation in the present time, as 2023 as we speak, has meant for investor confidence, market dynamics, and economic growth?
Thanks, Richa. So the Insolvency and Bankruptcy Code came alive in the year 2016. It's no secret that we were facing a NPA crisis at that time. And so we needed a framework to help resolve those NPAs. Prior to the IBC, there were a patchwork of legislation that dealt with the recovery of debt, but no one law that helped resolve stress. So, what the IBC did was to have one cohesive framework for the resolution of debt. And as you called it, sort of imaginative, one of the most important changes that it engendered was a creditor in control model. So far, there was the cliche that there are sick companies but no sick promoters, and that promoters felt they had a divine right to continue to be in control of their companies despite having defaulted on their debt, not having paid their workers and employees for long periods of time. And the IBC changed that in one fell swoop. It said that the moment you make a default, you could be taken into insolvency. And at that very stage, a representative of the creditors would be in charge of the company and not the promoters anymore. And this engendered a sense of corporate accountability. And it also instilled a sense of credit discipline for the first time. The other important thing that the IBC did was to treat all creditors alike. So whether you were a domestic or a foreign creditor, whether you were a bondholder or had extended a term loan through a bank, you would be treated alike on the committee of creditors. And finally, it was a market-based solution where potential bidders could try and revive the company, and the creditors would evaluate the best plan, vote on that, and then that would get approved by the NCLT and would get implemented. And I think the IBC is also symptomatic of how the courts, the regulators, and the legislature can come together to implement a really transformative reform. So the legislature, passed the IBC in record time, and then also continued to amend it where it was required based on market feedback. Now, it's also important to remember other countries that have had new insolvency codes. For instance, Chapter 11 in the US, when it first came about, was amended several hundreds of times, whereas the IBC has been amended. Major amendments have been restricted to sort of 4 or 5. So that was the role of the legislature. The new regulator, the IBBI, but also the RBI and SEBI, made a range of changes to encourage market players to use this new mechanism. And courts, including the Supreme Court in the Swiss Ribbons case, which Yash could talk about a little bit more, upheld the constitutionality, which gave immense confidence to the market, and it continued to be used and continues to be used. And we're at record NPA lows now at 5%, which will allow banks to make new funding to new projects and will, engender financial inclusion as well.
Yes, I think this speech definitely has been very transformative because in my capacity of being a journalist, there has been a definite change. Even the tonality of how promoters speak now post the IBC era. Otherwise, it really was that take the money from the bank and just forget about it. So it's really been transformative that has actually got the change in the mindset of promoters. For me, that has been a very significant piece of transformative law that we have seen, at least in the recent times. Now taking the conversation a bit towards the future, and we definitely need to talk about the rise of big tech, which literally has brought technology and law into a new era. What challenges and opportunities arise from the convergence of these two spheres, especially in terms of privacy, data protection, and innovation? I do understand that there's a very expansive data protection bill that's come about. And in fact, CAM has actually done a very meaningful exercise, and we've had a deep podcast on that too. But just sort of spending some 5 minutes on the rise of big tech and technology into new era, and then we can sort of take the conversation forward on climate litigation and AI.
Hi, Shrija. So I recently heard someone speak about the transformative changes that are coming not only in the legal world, but across the world with the coming of AI. where Lenin was quoted, and it was said that sometimes it takes decades for something to happen, but with what's happening with AI, it's in months that decades are happening. So,
True, absolutely.
so essentially that the amount of change that we are seeing is at a much higher order of magnitude than we have seen in the recent past. For example, the Chat GPT 4.0, which is the new language learning model that has been developed by OpenAI. We have been using that, and we've been asking it to compose haikus for us and limericks for us, and even first drafts sometimes for legal documents. Um, but I mean, we haven't seen that as very reliable. But what we understand is the Chat GPT technology that has been that is functioning at this moment or for the last 6 months, maybe 2 years down the line, we look back and see it as very rudimentary. We'll be far ahead. We'll be viewing it as what we view Windows 95 as today. So, of course, the impact of AI on work has some very serious implications. And I think every organization, particularly professional services organizations like management consulting firms, law firms, and what have you, are seriously considering how they can incorporate these technologies into their everyday functioning. Um, but more importantly, we will see, from a regulation point of view, we will see, we've already seen in the EU Parliament has brought about the AI regulation law, which, as many consider, the EU sets the standards for the world. So, like as they did with the GDPR. So we have to wait and watch as to what impact that the AI Regulation Act has on the rest of the world. But we are yet to see. Regulation always follows technological developments, but we are yet to see as to how this space will develop. Just one more point. There's always been two schools of thought. Not always. In the last year, we've seen it developing towards AI, and it's important which bucket we categorize ourselves in. One is the Bill Gates school of thought, which, if you read his recent article, which was quite the rage, in which he says that AI will only enhance productivity, and we shouldn't view it as as a negative force, and that we should see it as only enabling humans to do more. That's one school of thought. The second school of thought was a recent piece in the New York Times by the person who helmed the AI program at Google, who, as everyone's seen Oppenheimer recently, he was in a very much Oppenheimer kind of mode.
Situation.
That I've created something that can possibly have very serious ramifications for
Like
humanity.
unleashing the monster and then regretting it, pretty much.
Correct. So I think these are the two extremes that everyone dealing with. I mean, first of all, everyone should read those two pieces to understand what the extremes are. But
So Yash, that really is the crux of the matter. We really at the crossroads here, right? AI as an enabler, as transformative, and second, AI as one which displaces our job, which displaces the human mankind. Perhaps the jury is still out on this one. Richa, you have any view in this direction? What do you think perhaps where the future will tilt towards, in which bucket?
Yeah, just to briefly supplement this, Shija, specifically on big tech, I think, in addition to AI, I think big tech in any event has such an outsized impact on each of our lives that I think there is a risk that they are arrogating to themselves certain powers of the state. So, for instance, they run what used to previously be called the public square. So they are effectively in charge of adjudicating free speech, which is a function that the state has to carry out. So this raises sort of important questions around how big tech should be regulated, because they are in effect mediating on important rights that we have as citizens, and we have as global citizens. And how is this going to work in a situation where we have sovereign boundaries which may have sort of vastly different ideas of what constitutes rights for those citizens, right? So there are some states, there are some countries where we take free speech for granted, and there are others which don't. So that's one set of issues. The other is, just the sheer scale of big tech, and the fact that they've been making more and more acquisitions and becoming bigger and bigger, and therefore permeating every aspect of our lives, which raises important questions of competition law. And here again, as we discussed previously, the EU has been taking a lot of action on this front to rein in big tech, as has the US. The new FTC, chaired by Lina Khan, has been taking a lot of action in this context, and we're probably going to continue to see much more of that. So I think that's a second strand. And then finally, with AI, there are sort of questions around whether and how we can regulate it. So an AI engineer will tell you that AI is not really explainable because we teach it up to a point, we feed it certain data up to a point, but thereafter it teaches itself. And so we can't be sure, how a certain outcome came about on AI, which raises very scary, perhaps, questions about how AI should be regulated. I think that's one aspect. And the other is that AI embeds in itself certain flaws that humans already have. So, as we're looking at AI to replace humans, there is the risk, of course, that human flaws such as bias and prejudice, whether it's racial or gender related or related to faiths, etc., can get not only embedded in AI but compounded and amplified by it. And that is something to be quite wary of.
Thanks for that. We can actually spend hours and hours just discussing artificial intelligence, its impacts on human mankind. So many people have actually come forward and have actually regretted what Yash was talking about, that they have pretty much unleashed the monster and rethinking on what the future course of action really will be. We had a very interesting conversation today. I particularly really liked the part in the commentary we spent on the constitution bit, and then the conversation moved forward to the transformative legislation. We spent some time on IBC. We spoke about the role of big tech. And as we peek into the future and perhaps conclusion to this podcast, we got to talk about something which really seems to be the new buzzword, and perhaps not so much understanding is there, which is about climate litigation. Seems to be emerging as a powerful tool for environmental protection. What do you think is the role of the Indian policymakers in addressing climate change and holding industries accountable for their impact? How do you see the legal system's role in holding not just corporates, but also governments accountable for dealing with climate change?
So, Shrija, climate litigation, yes, is a new buzzword, but it's been around, I would say, for 7 or 8 years. A recent report by the Columbia Sabin Center for Climate Litigation has said that there's across 65 jurisdictions, currently there's about 2,180 cases that are pending. So there's a lot going on. Most recently, I'll just tell you a couple of examples and what the challenges are. I'll come to the challenges first, because the cause of action for anyone bringing a suit against or a case against a company will be as to that company's duty of care or the board of directors' duty of care towards the persons affected. But the big issue at the moment that people are grappling with is how does one attribute the harm? Like if there's climate change, if there's certain ocean water level rising, and there's certain coastal communities that have been affected by it, how does one attribute that to a company operating on another continent? So those are the challenges that you are dealing with. But to give you an illustration, there's a German court in Mannheim that has issued certain directions against companies based out of Germany for certain pollution effects that people are facing in Latin America, in Chile. Similarly, recently, Shell, for the first time, by a court of first instance in The Hague, has their board has been asked to, to exercise a duty of care for similar challenges that are faced. Similarly, now coming to India, we haven't yet seen particularly widespread climate litigation. But one case that has recently, caught the eye is the case of the great Indian bustard, which is a rare endangered bird. And there's another bird called the lesser florican in Rajasthan, in one of the national parks in Rajasthan. Now, this was in the case by the Supreme Court was decided on in April of 2021, and it's the first time that the Supreme Court has observed that companies, and particularly board of directors, quoting Section 166, subsection 2, that board of directors of a company have a duty not only towards its shareholders but also towards the environment, and so on and so forth. So it's really like they've just cast the door a bit aside to expand the duty that directors have towards the environment. In this case, it concerned electricity wires that were passing through the national park, which would fall in and damage, harm the bird. Now the court has ruled that in areas where this population of the bird resides, all the wires have to be underground. So that's the tangential effect of it. But as I said at the outset, there are certain larger attribution challenges as to, when you go to court, there's a thing called standing. You have to show that you've been negatively affected by something. So there's a whole science that is developing as to how has climate change actually affected a particular person or a community, and how they can bring an action against a particular corporate. So this is still a developing field, but I'm sure we'll see more progress on this in the future.
My effort with this podcast really has been to dwell on the past, the present, and the future. We as a country are really standing on an interesting juncture as we reflect sort of very proudly on this constitution, which really has been a living document. We're also talking about areas like universal basic income in the face of AI. It's been a very interesting whole swath of phenomenon that we have seen for a country which is so young. Let's get to 100 years of Indian independence, and let's sort of imagine and envisage that it is 2047. A very quick takeaway from both of you, not more than a minute each. What do you envision would be the biggest changes to Indian law as compared to 2023? And we bring this entire discussion to a close then. Yes.
I think it's important that the new laws we have at 100 years of independence will be built on the edifice of our very unique constitution. So you talked about UBI in the context of AI, and it's important to remember that some of the women who were part of the Constituent Assembly had already talked about that. So I think some of those principles are important to be preserved for dealing with any future challenges. So I would imagine that our constitution will be alive, the institutions created by it will continue to remain independent, and that new laws that deal with emerging challenges, whether it's technology or climate litigation, which includes important things like holding the state accountable, will have come about and will be being negotiated using the really sort of strong principles and the philosophy that the Constitution has gifted us.
Okay.
I would echo Richa. I was going to say the same thing actually, which is essentially that we'll always have historical developments, technology. There'll be experts. We'll always keep up with the times, but it's important. What's important is the foundational norms that guide that action, and that comes from our constitution and the framers who founded it. So if you're asking me in 2047, I would very much expect and want and desire that the country abides and continues to live by the constitution. And particularly, we've spoken a lot about the technological and business aspects, but more importantly, it's the softer aspects, such as fundamental rights, such as the clarion call of the preamble, which speaks about fraternity and the dignity of the nation and each individual. I think those are far more important than all these technological developments. So, as a citizen of the country and as a citizen of the world, I definitely feel that these founding tenets should guide us forward and will be the differentiating factor.
So the founding tenets will be the differentiating and the guiding factor, even if we get 200 years of independence, and that will sort of continue. Thanks for that, Richa and Yash. And so, Cam Radio celebrates this historic milestone. We have explored the very fabric of our unique constitution, unraveling its threads of justice, liberty, and equality that have guided Cam's legal journey. We have explored legislation that are not just mere laws. They are pillars of innovation that have upheld the edifice of a new India. As we bring this episode to a close, let's reflect on the echoes of progress that resonate from our past into a promising future. So, as the clocks tick forward, we find ourselves at the intersection of past, present, and the future. The converging forces of private and public law, the dance between technology and jurisprudence, and the symphony of artificial intelligence and climate litigation are shaping the contours of our legal landscape. So, carry forward the torch of knowledge that has illuminated our discussion today. Thank you for embarking on this exploration with us, for engaging with the depth of ideas and aspirations that define India's legal landscape. Happy 76th Independence Day, and from Cam Radio, may the flame of justice forever burn bright. Thank you.
Thank you.